I'm Zach Klein, Chair of the Public Safety Committee on the Columbus City Council. Welcome you to the annual liquor permit renewal objection process. Tonight we have an agenda that involves members of the police department as well as members of the city attorney's office that are going to discuss the process necessary for objecting to liquor permits that various entities hold in the city of Columbus. So at this time, I know the Honorable Richard C. Pfeiffer is here, Columbus City Attorney. Are you interested in saying any few words? Okay, I'm going to turn the microphone over to the City Attorney.
Chair Klein, thank you very much for this opportunity to present to you the opening stage of allowing the community to understand the process by which liquor permit holders can apply for a renewal of their permit, and the opportunity that you as part of the legislative body and your colleagues have to object to renewals for those establishments that aren't following the law correctly. Our key point person on this is Assistant City Attorney Bill Sperlazza, who will present to you this evening the process by which we go through this effort to ferret out the permit holders who the community finds and we find sufficient evidence to show that they're not living up to their responsibilities. So thank you very much, Chairman Klein.
Thank you, City Attorney Pfeiffer, and I think I don't want to take Mr. Sperlazza's thunder, but I know that the first step is identifying establishments, and so I want to take this opportunity to make it known that we welcome input from the public. The input from the public is a primary driver in this process, so that if you feel that you live in a neighborhood where there's an establishment that has a liquor permit and that establishment is participating in criminal activity as a nuisance on your neighborhood, then please follow this process, figure out who to contact, which will be outlined in this process, so that we can go through the proper channels to hold those people accountable and clean up your neighborhood, because that is the primary reason why we are doing this, is to hold people accountable for their actions and to clean up the neighborhood so that everyone has a strong and safe neighborhood to live in. At this time, Mr. Sperlazza, the floor is yours.
Thank you, Chair Klein, City Attorney Pfeiffer, ladies and gentlemen. Very happy to be here tonight to talk to you all about our annual liquor permit renewal objection process. I have some slides up here, hopefully you all can see on the television screens. I will go through the slides and address the different steps. There are 8 major steps as it pertains to the permit renewal objection process. The first step is identifying problem establishments. The second step is the investigation process. The third step is evaluation. The fourth step is the City Attorney's recommendation to Council. The fifth step is Council's resolution to the Division of Liquor Control. Sixth step is the Division holds a public hearing. The seventh step is that the Division issues a decision. And finally, the 8th step is the appeals process. We'll go over each step individually. Step 1, identifying the problem establishments. A letter went out to various community groups, area commissions, civic associations, other neighborhood groups, indicating kind of the kickoff of the liquor permit objection season and process. How do we identify problem establishments? What are the sources that we derive this information from? First of all, certainly law enforcement. The Columbus Police Department, the Ohio Investigative Unit, Franklin County Sheriff's Office, various law enforcement offices, primarily the Columbus Police Department and the Ohio Investigative Unit. What other sources? Community resources. That's, again, area commissions, civic associations, other neighborhood groups, individual citizens. This certainly is a step where citizens and area commissions and such can get involved, be a part of the process, and communicate to us if there are any liquor permit establishments in their neighborhoods that may be causing problems. The body of the letter, which is shown here on the slide, hopefully many of you who are here today or listening have received that letter, does show my contact information. I am Assistant City Attorney Bill Sperlazza. My direct phone number is 645-7479, 645-7479, and problem establishments can be brought to my attention as well. What types of establishments do we tend to target? Certainly they are those that operate in a manner that demonstrates disregard for the laws, regulations, or ordinances. These types of establishments cause substantial interference with public decency, sobriety, peace, and good order. And we need and require substantial, reliable, and probative evidence to pursue a liquor permit objection. We do not operate on rumor or perception or innuendo. We need hard evidence to move forward. Step number 2 is the investigation process. Various entities are involved in the investigation: Division of Police, Division of Fire, the Health Department, Code, the Ohio Department of Public Safety once again, and other, the criminal courts through their criminal convictions as well. However, I would say that the Columbus Police Department certainly is the primary source of investigation in these cases. And at this time, I'll briefly turn it over to Detective Alan Brown here to my left. He is the Liquor Liaison Officer with the Columbus Police Department, and he will discuss the investigation process via the Columbus Police Department a little bit further.
Council Chair, Council Chairman Klein, Mr. Pfeiffer. The device section investigates prostitution, gambling, liquor law violations, and other related crimes. This includes investigating and evaluating establishments, liquor establishments, for the issuance of liquor permits, the annual renewal of the liquor permits, and the transfer of liquor permits. When a liquor establishment for possible objections, the vice section considers the following conditions in relationship to a liquor establishment investigation: violations of city and state law, liquor law violations, health code violations, fire code violations, building code violations, other licensing issues, police dispatch runs, police reports taken, and any other condition that affects the peace, sobriety, and decency of the community. In doing this evaluation, the advice section evaluates approximately 150 different liquor establishments each year for possible objection to the renewal of the liquor permit. This list then is cut down to approximately 5 to 15 different establishments that we would actually object to. This list also includes those liquor establishments which receive liquor and criminal law violations within one calendar year. Okay. It is if a citizen or a group of citizens have any problems with certain liquor establishments or areas in our city, or prostitution or gambling, they can contact the Vice Section of the City of Columbus at 645-4705. Thank you.
Thank you, Detective Brown. After the investigation process, we then move to step 3, which is the evidence evaluation step. At this time, myself, Detective Brown, other members of the Columbus Police Department meet with Councilmember Klein and his staff to discuss the evidence that we have obtained up to this point. And again, I'll stress this again. What are we looking for? We're looking for legally sufficient evidence to support an objection, evidence that is substantial, reliable, probative evidence. We take time to evaluate the evidence that is the result of the investigation, and we then begin to determine what liquor establishments will be recommended for objection. What specifically are we looking for as it pertains to evidence of a liquor establishment? Number one, liquor violations. Obviously, this process pertains to the liquor permit, and the Division of Liquor Control wants to know how the establishment, how it has handled the privilege of having a liquor permit. Are they, do we have confirmed sales to individuals under the age of 21? Do we have improper packaging of alcohol? Do we have alcohol sold after hours, after the permit allows? Things of that nature. Secondly, we're looking for criminal activity at a liquor permit establishment. In particular, violence. Has there been a pattern of violence at this establishment? This could be, shootings, stabbings, fights, things of that nature. Drugs, prostitution, also are good indicators of a potential objection. In addition to those types of things, we also consider EBT or WIC card fraud. That would be food stamp fraud, or if the establishment is acting as a fence for stolen property, buying and reselling stolen property. Those are just some examples of the types of criminal activity we look for. And then finally, we also have code-type violations. Obviously, violations issued by the code department, fire, building, health, anything like that will be considered. All right, the next step would be the city attorney's recommendation to council. Once the investigations have been complete, once the evidence has been evaluated, then City Attorney Pfeiffer will present letters to City Council indicating which establishments we believe have legally sufficient, reliable, and probative evidence to ethically move forward on an objection. The next step, step 5, is the City Council resolution. Near the end of the year, at a City Council meeting, the potential objections are presented to City Council in the form of a resolution. That resolution for each individual premises is again presented to Council, and it is voted on by City Council. If City Council votes to pass the resolution to object to a particular liquor establishment, then that resolution in and of itself is the objection. The information then is sent to the Division of Liquor Control, the Ohio Division of Liquor Control, and a hearing is required. And at this point, I think it's important to point out an important distinction. I've certainly had some instances where folks, citizens, business owners have come to me and said, Bill, why did you allow a liquor permit to come into my neighborhood? Why did the city give this bar a permit? Why did City Council allow this permit to exist here? The City of Columbus does not grant or deny liquor permits. That is an act of the state of Ohio through its Division of Liquor Control. So it's important to understand that distinction. The City of Columbus, through a resolution of council, may object to the renewal or to a new permit in the City of Columbus, but ultimately it's up to the state of Ohio through the Division of Liquor Control to make a decision as to whether or not they will grant a liquor permit or whether or not they will sustain or overrule our objection to a renewal of a liquor permit. Step 6 is the public hearing at the Division of Liquor Control. For each permit that is objected to, the Division of Liquor Control will then set a hearing where a hearing officer at the Division of Liquor Control will oversee the hearing. At that hearing, I represent the city and I present evidence that supports our objection to the renewal of that permit. The permit holder may also be present. He may also present evidence, and he or she often has an attorney there representing him. Again, I present evidence to the hearing officer in favor of the city's objection. What type of evidence is that? Typically testimony by law enforcement. Detective Brown often testifies. Other various Columbus Police Department officers, Ohio Division of Public Safety officers also testify. We also enter in a lot of paper evidence, a lot of certified convictions from court records, be that convictions for underage sales of alcohol or various acts of violence or criminality within the establishment. After the hearing, the Division of Liquor Control will issue a decision, not on the day of the hearing, but typically and unfortunately 1 to 2 months after the hearing is held. Sometimes even longer than that, as we'll see coming up. After the hearing, like I said, step 7, I did not indicate that as step 7, that's when the division will issue its decision. What are some of the possible outcomes of a hearing or of a permit objection? Well, if we have a hearing, number 1, the division may rule to sustain our objection, and that means they agree with the city's evidence and they decide that the permit should not be renewed for the reasons presented at the hearing. Secondly, the division can overrule our objection. At that stage, the division is telling us that they did not believe the city provided a sufficient case to establish the objection, so they do allow that permit to go ahead and renew and continue to operate. Permit forfeited is kind of a catch-all term that we use. It's common, once a permit is objected to, for a permit holder, and I use the phrase, wave the white flag. They realize that there's a pretty good case against them. They do not wish to fight it at a hearing, so they decide to no longer renew their permit, withdraw their renewal, whatever it may be. But if the permit holder decides to remove their renewal permit, or renewal application, excuse me, then there will not be a hearing because the division considers the issue moot and the permit is not renewed. So in the overall kind of easy terms of wins and losses, we consider that a win because that permit was not renewed. And either way, well, strike that. If a hearing is held and the division offers either a sustain to the objection or overrule the objection, then the losing party may choose to appeal. Now, I want to hit two quick points before I move to the next step. First, what does it mean to have a permit forfeited or an objection sustained? Again, that means that the permit is not renewed. That individual cannot seek the permit at that location for that calendar year. That doesn't mean that somebody else couldn't perhaps buy the property or get into some sort of management agreement with the property owner and then seek a new permit with the division to operate a new establishment. However, we do have the opportunity to object to that as well and can present much of the same evidence in that regard. Secondly, it's often asked, what happens to the establishments during the objection process? Well, during the investigation and the evidence evaluation, during all of the objections, and even during the hearings, the permit holder's permit is still active and they are allowed to use it and to sell alcohol pursuant to their permit. Once, in the event that the objection is sustained, on the day it's sustained, the permit holder has 30 days to file a notice of appeal. During that 30 days, the permit is still active as well. However, once the permit holder files his notice for appeal, then they would, if they do not file the notice of appeal, then the permit at that point is terminated. It's no good. They no longer have the right to sell alcohol. If they do file a notice of appeal, they do intend to appeal, they want to appeal the decision, then the Liquor Control Commission decides whether or not the permit will be active during that appeals process. We have an opportunity to object to the permit being active during that time. In my experience, typically, the permit is not allowed to be practiced. It is not allowed to be in use during the appeals process. And step 8, the appeals process itself. Again, there are multiple layers of an appeal here. The first is the Liquor Control Commission. De novo, that's a fancy way of saying as if anew, so essentially we have to do the whole hearing over again. If they don't like the ruling they get at the Liquor Control Commission, they can appeal to Common Pleas Court. If they don't like that decision, they can appeal to the Court of Appeals. And finally, if they don't like that decision, they can appeal to the Ohio Supreme Court. Technically, that's what can happen. Practically, I've never seen an appeal go past the Liquor Control Commission stage. I would say it is typical for a permit holder who's, when the objection has been sustained, they 75% of the time or so, they do end up appealing. But again, it only goes, in my experience, as far as the Liquor Control Commission. Again, they have 30 days to file a notice of appeal. And at that appeal, the Attorney General's office essentially takes my space. If you think about it, the Division of Liquor Control made a ruling, that's the state of Ohio. The permit holder is appealing that ruling, the state's ruling, so that's when the Attorney General steps in to represent the state in that regard. I will typically act as co-counsel or at least advise them to some degree. The Liquor Control Commission is a 3-member panel that will eventually make that decision. That's the 8-step process. Now to just do a quick review of our, what I would call our 2013-2014 objections. The objections that that City Council passed in December of 2013 that we have had hearings on this year and are currently pursuing. more than 100 establishments, probably closer to 150 establishments investigated throughout the year of 2013. City Council passed 12 resolutions to object to 12 permits. And I don't know if you can see this very well, but this is kind of a chart indicating what has happened with those permit objections thus far. 3 of the permits have been what we call forfeited. Again, that's that waving the white flag that I indicated earlier. The permit holder decided that they realized their permit was being objected to. They didn't want to put up a fight. 1 objection went to hearing and was overruled, unfortunately. And we have 8 remaining permits. 6 of them are awaiting division ruling. That means that the hearing has been conducted and we're still waiting on the division to rule. 2 of them, we're awaiting a hearing to be scheduled. So in this case, the Division of Liquor Control has yet to even schedule a hearing for us to present our evidence. And again, I don't know if you can see it, but just to give you an example, if you look at Food Max, which is 1, 2, 3, 4, 5, 6, looks like about the 7th one down. We are still waiting for a ruling on that case. Our hearing was January 30th of 2014. That's an unfortunate situation, but again, it's the Division of Liquor Control that eventually will rule on this. So we would hope that they would do it a little bit sooner rather than later. And again, those are just the numbers we talked about. 8 still pending, 6 awaiting a ruling after a hearing, 2 awaiting a hearing to be scheduled, period. And finally, just a quick update on our 2012 objections. We objected to 9 permits. 7 of them are what we would call a win. 5 were canceled or forfeited, wave the white flag, if you will. 2 of our objections were sustained. And 1 of those objections is currently under appeal, but I don't know if it's going anywhere. And during that appeal, that particular establishment cannot operate. 2 of the 9 permits, the objections were overruled. So of our 9 objections last year, we were 7 out of 9 in terms of what we call wins or victories. And that concludes my overview of the process and our review of 2012 of 2013. And I'm certainly open to any questions from you, Chairman Klein, City Attorney Pfeiffer, or any folks here in the gallery. Thank you.
Thank you, Mr. Sperlaza. Anyone want to comment from the police department? Any further commentary? Okay, City Attorney, do you have any further commentary? Okay, thank you. We have no speaker slips. And so at this time, that'll conclude the hearing. I just would like to note again how important it is for members of the community to help start this process. That if you feel like there is an establishment in your neighborhood that has a liquor permit and that establishment is wreaking havoc on your neighborhood, there's criminal elements, it's unsanitary, whatever it may be, as Mr. Sperlaza identified the checklist of the team that goes in. But really what we're focused on is if that establishment is a nuisance in your neighborhood, if it's providing criminal activity, if there's violence, if there's underage drinking, let us know so that we can start looking at and investigating a case to be built for a liquor objection for the state of Ohio so that we can maintain quality neighborhoods in the city of Columbus. And it starts with the citizens and it starts with the people of the city to get that process rolling. Thank you, Mr. Sperlaza, for your input. Members of the police department, thank you so much for your input. And that concludes our hearing. Thank you.